Most people think deportation starts at the border or in a courtroom, but in some cases it starts long before that, quietly and without you realizing it. It usually begins with something that doesn't even look like an immigration issue. If you or anyone you know is not a US citizen, stay with us, because what we are about to show you will change how you think about your status in the US. Most people assume that if the government wants to deport someone, there usually is a process, a notice, a hearing, a judge, or a chance to speak. And for many people, that is true. But there is another process, one that most people have never heard of. It is called expedited removal, and under this process, a low-level immigration officer, not a judge, can order your removal from the United States. No hearing, no lawyer, no appeal, just one interview, one decision, and you are gone. In some cases, in as little as a single day. Now here is what makes this more than just a legal technicality. This process does not only apply to people who just crossed the border. It can apply to people who have been living inside the United States. People with lives here, families here, and jobs here. And it can be triggered by something that has nothing to do with immigration at all. Here is how it often begins, from a routine traffic stop, a minor interaction with law enforcement, a check at a workplace, or simply being in the wrong place at the wrong time. The moment an immigration officer becomes aware of you, the clock starts. And here is what most people do not realize. That officer has the authority to make a determination about your status on the spot. No courtroom and no immigration judge reviewing the evidence. Just that officer at that moment making that decision. The law permits a low-level immigration officer to serve both as prosecutor, charged with enforcing the law, and as a judge, rendering a final decision on the case. One person, two roles, with your future in their hands. And the entire process involves a single interview while you are detained. You have no time to call a lawyer, to gather evidence, or to contact your family. Does this sound like something that could never happen to you? Stay with us, because the next part is where most people get it wrong. Here is what the system will not tell you up front. Expedited removal is not limited to people who entered the country without documents. Under its expanded application, it can reach people who entered legally, but whose status has since lapsed or changed. The risk is significantly higher if you entered the United States without going through an official checkpoint. Also, if you cannot prove that you have been continuously present in the country for at least 2 years, or if your immigration status has changed, and you are not aware of it. And here is the detail that stops most people cold. Even lawful permanent residents, even people with green cards, can be wrongly swept into this process. Because the officer makes the initial determination, and mistakes happen. There will almost certainly be instances of people with valid asylum claims or other removal defenses being deported without being able to make their case to an immigration judge. Not because the law says they should be deported, but because the process moved faster than anyone could stop it. Now, you might be thinking, I have documents, I have status, this cannot happen to me. Here is the part of this process that most people never consider. When you are placed in expedited removal proceedings, you will likely be handed documents to sign. These documents may be presented to you as routine paperwork. They are not routine. In some cases, signing those documents means you are voluntarily agreeing to leave the United States without a hearing, without seeing a judge, without any further review of your case. Immigration officers have been known to pressure people into signing by suggesting that refusal means remaining in detention longer, or that signing is the only way to resolve the situation quickly. Do not sign anything without speaking to a lawyer first. This is the most important thing we will say in this entire video. Do not sign anything, even if an officer tells you that signing will make things easier. Even if you are frightened, even if you are alone, state clearly out loud that you wish to speak to a lawyer. And if you have a fear of returning to your home country, state that fear clearly and immediately at every opportunity, because that fear claim is one of the few protections the law gives you in this process. So here is the intelligence Borderline Access exists to give you. 3 things to do before this process ever touches your life. 1. Carry proof of your status with you at all times. A copy of your visa, your green card, your immigration court notice. Any document that proves your right to be in the United States. If you are stopped, present it calmly after you have asked to speak to a lawyer. 2. Know your 2-year presence if you have been in the United States for more than 2 years. That matters legally. Keep records, bank statements, utility bills, lease agreements, anything that proves continuous presence. 3. Never sign immigration documents under pressure. Read everything, understand everything, or refuse to sign anything until you have legal advice. A signature in the wrong moment can remove rights that took years to build. Deportation does not always start the way you think it does. It does not always start at the border, and it does not always start in a courtroom. Sometimes it starts with a routine encounter, with a piece of paper, with a single interview, or with a single officer. And by the time most people understand what is happening, the process is already moving. That is how it starts. Not at the border, not in court. It starts quietly, before you even realize what's happening. But where it ends, most people never see coming. That is part 2. Subscribe to Borderline Access so you do not miss it, and drop your questions in the comments below, whatever is on your mind. We read every single one. Navigate the divide. This is Borderline Access. We will see you at the next border. The content on this channel is for general educational and informational purposes only, and does not constitute legal advice. Immigration law is complex and subject to frequent change. Nothing in this video should be relied upon as a substitute for professional legal advice. Always consult a qualified immigration lawyer before making any decisions. Information is accurate at the time of this report.